Okay, hello everyone, and welcome to For the Record. What are your ethical obligations to create one? Before we get started, I want to go over some logistical bits. In order to turn on or off the live captions, you can press the button with the CC symbol at the bottom of your screen. You might have to click the More button to find that. Zoom loves hiding those buttons. This session will be recorded and will be uploaded to the LAC website within 1 week of today's event. And you also receive your MCLE certificate within 1 week to the email address that you used to register for the training today. This training is eligible for 1 hour of ethics MCLE credit. Please feel free to use the chat function to ask your questions. We'll answer them as we go and at the end. And by we, I mean our presenters, of course. and we will also have a couple of polls, so keep an eye on your screen if you would like to participate in the polls. And with that, I will hand it off to our wonderful presenters. Thank you so much.
Thank you, Kasha. Hi, everyone. We know folks are still trickling in, but we are going to get started. We have a lot of content to cover today. I want to thank you for joining us. We are very excited to talk to you about securing a verbatim record for your client and your ethical obligations to do so. This is a topic that Jennifer and Erica and I are very passionate about. As Kasha said, we'll try to answer questions as we go. So just pop them in the chat if you have any.
Brenda, do you want to introduce yourself?
Oh, yes, I will. Thank you. Sorry, trying to figure out the slide wasn't going. So my name is Brenda. My pronouns are she, her. I'm the Director of Litigation at Bay Area Legal Aid.
And I'm Jennifer Wagner, also she, her pronouns. I'm the Director of Programs at the Family Violence Appellate Project.
And I'm Erica Edinger, also she, her, and I'm a senior attorney in the Systemic Impact Unit at Community Legal Aid SoCal. Sorry for not being on camera today. I've gotten an ill-timed cold. Before we start, we have a quick disclaimer. We, along with our partners at Covington and Burling, have filed a lawsuit challenging the court's failure to create a verbatim record. And that case is pending before the California Supreme Court. Since it's currently in active litigation, we're not commenting on that case today, other than to note that oral argument was just scheduled for June 3rd. And it will be live streamed on the California Supreme Court's website if you're interested in tuning in. It'll also be happening here in LA. Today's training addresses what your current obligations are under the law. Also, we'd like to give a shout out to Toby Rothschild, who consulted with us and provided his invaluable ethics expertise.
By the end of this training, you should have a better understanding of what a verbatim record is, why it's important for your client, and why your client may not have one, what your responsibilities are under the ethical rules to inform your client of their right to a verbatim record, explain their options, and get informed consent, and what protections currently exist and how to go about requesting and ensuring a verbatim record is made of your client's proceedings.
All right, so let's start with our first poll. We're going to try to be quite interactive today. We're going to have some hypos as well. So let's start with a poll. The first question is, are you aware that there is a court reporter shortage in California and that hearings are going unreported? I think there's a very strong favoring for yes. Give folks a few more seconds. I think we have most people. All right, let's close the poll. So it looks like about 87% of folks said yes, they are aware of that, and 13% are not. So for some of you, these initial slides will be a little refresher, and for others, this will be some new information.
So before we get into the ethics around securing a verbatim record of court proceedings for your clients, you'll need to understand why a verbatim record is important. Verbatim records are important because they're the most accurate version of what happened in the courtroom. They're word-for-word records. Other alternatives, like a minute order, for example, or a findings and order after hearing, or a settled statement, are just summaries. And they're often dependent upon people's recollections and notes. And because of this, they can contain inaccuracies. And these alternatives can also be really challenging to get, especially when the litigants are self-represented or there are contentious issues involved or domestic violence involved. The opposing party may not agree with you on what the court did or said, and a judge may have to settle any disputes based on their own possibly faulty recollection.
A verbatim record is essential for preserving your client's ability to appeal incorrect trial court decisions. This is because the burden is 100% on the person challenging a trial court to prove it was wrong on the law or abused its discretion. As the California Supreme Court has said, the lack of a verbatim record will frequently be fatal to an appeal. Since FVAP began tracking this specifically, we have turned away dozens of potential clients who did not have a certified shorthand reporter or electronic recording at their hearing. Just as an example, we were forced to decline an appeal where the trial court denied a survivor's request for a domestic violence restraining order, and there was no verbatim record. The potential client remembered that the trial court had told her it believed her about the abuse, but it didn't think a restraining order was necessary because the parties were no longer living together. That would be a reversible legal error. And if we had a transcript, we could have gotten her a new trial or even a directed restraining order. Months later, a different trial court judge decided the parties' custody proceeding at another hearing that also did not have a verbatim record. The custody court's written order gave the parties joint legal and physical custody without discussing the abuse allegations. Without a record at the second hearing, we couldn't determine if that second judge fulfilled its independent obligation to determine if there was domestic abuse or failed in that duty and wrongly relied solely on the previous restraining order denial to determine there was no abuse and then to grant joint custody. It wasn't possible for us to challenge either of those orders without a court reporter. And if these allegations were true, it's a very dangerous situation for this family.
So I think most people are already aware of what Jennifer was talking about, that a verbatim record is really essential for an appeal. But I think something that gets overlooked is how essential it is to effectively litigate at the trial court level. And that's because, these cases go on for years. Often you might get different judges assigned to the case throughout its lifetime. Without that verbatim record, any new judges, they don't have the full picture, and they might make some orders or findings that are inconsistent with a prior judge. It can even happen with the same judge, right? Memories fade, and that can lead to inconsistent orders or incorrect orders. I wanted to provide just a few examples of how I think this can come up. So let's just say your client is a family law client. They are trying to modify a custody order, right? It's a final custody order. They have to show that there was a change of circumstances. Without that record, even just the same judge, let alone a new judge, might not know what the circumstances were before precisely that have now changed, and they might make an inconsistent or incorrect order. Another example, you're in court on a motion to compel. The other party has behaved terribly, but the court decides not to sanction them this time, but admonishes them very strongly. If I see you again on this issue, I'm going to sanction you $1 million. And you walk out really happy. And then there's a new judge that hears the next motion to compel. There's no record from the prior hearing. They allow further discovery abuses. Another example is there are, certain post-trial motions that really require a record. For example, a motion for new trial that requires showing that there was some kind of irregularity in the proceedings, newly discovered evidence, etc. It's really nearly impossible to bring a motion for new trial if you don't have a record of what happened at the trial court. Oh, and I'll just add one more thing, which is a personal example. So a while back, I actually came into a trial 4 days into it. It was a 10-day trial overall, and I took over the trial 4 days in. So I had to read 800 pages of transcript in order to get caught up. I cannot even imagine how I would have jumped into that trial if I didn't have that record. It would have been impossible. All right, so how about another poll? This is an easy one, true or false, only two options. Verbatim records are only important if your client's case goes to trial. True or false? Okay. Great. I think we can close the poll. Thank you. Maybe am I supposed to share the results? I'm not sure. I'm going to say the results, which is 100% of folks said that that is false. And you are right. Verbatim records are important for all different kinds of proceedings, right? Of course, trials, evidentiary hearings, law in motion, case management conferences, trial setting, ex parte applications. The reality is, as we all know, because we've all been there, you cannot always predict when something bad is going to happen, right? Maybe there's a brand new judge, maybe there's a pro tem that day, who knows? It could happen, there could be a routine procedural thing that you're there to discuss, but it snowballs into some substantive discussion. Even just a trial setting, I can imagine where you're telling the judge you're not available because you're in trial in another case, or you're, out of the country on vacation, and they schedule it for that time nevertheless. That might be something that you could have writted or appealed, but now without a record, that's going to be nearly impossible.
Verbatim records are also important for ensuring judicial accountability. The Commission on Judicial Performance has reported that 95% of the complaints it receives are about judges' actions during court proceedings. The standard there is clear and convincing proof of misconduct. The Commission itself has recognized it can be very difficult, if not impossible, to establish what was said or occurred in a courtroom without a record of the proceeding. And that makes it unlikely that a complaint could succeed without a verbatim record. And just to give you a flavor of some of the things that come out in these records, we've been involved in a few judicial complaints. One involved the court yelling at a 12-year-old for not forgiving his father for abusing him in a custody proceeding. Another was really blatant homophobic remarks at a restraining order hearing where the parties were gay. Both those judges had disciplinary action taken against them based on those transcripts, and luckily aren't in those positions anymore. Imagine if we hadn't had a transcript.
Courts at all levels have recognized the importance of verbatim records for equal access to justice and due process. We have another audience poll. Have you heard of the California Supreme Court case Jamison v. Desta? I'll give folks a few seconds to chime in. Looks like folks are still weighing in. Looks like there's a mix of responses of people who are familiar with it. I think we can go ahead and close the end the poll, and I'll read out the results. 9% say yes, and I use it all the time. 23% say yes, but I have never used it, and then 68% said no. So you're in luck, because we're going to talk about it next. Jamison v. Desta is the major case on this topic. The California Supreme Court held that equal access to justice for low-income litigants requires a verbatim record of what is said in court. The court said that if courts generally do not make court reporters available but allow parties to hire and bring their own, they must provide a court reporter for litigants who are eligible for a fee waiver so that they can also have access to a verbatim record. And the California Court of Appeal has similarly recognized that the lack of a verbatim record raises due process and equal protection concerns. I won't read out the quotes here, but we've included the language from case law for your reference.
So if a verbatim record is so important, why are so many litigants being deprived of one? Historically, court reporters have created verbatim records of all court hearings. In recent years, however, courts across the state have been plagued by a shortage of court reporters. The shortage has now reached a tipping point, with many superior courts calling it a constitutional crisis. According to the Judicial Council, since April 1st of 2023, more than 2 million hearings in unlimited civil, family law, and probate proceedings have taken place without a verbatim record. The shortage does not affect litigants equally. Wealthy litigants can afford to hire a private court reporter, while those without the ability to pay are ending up without a record. And in limited civil cases like small claims and unlawful detainer actions, you may still need to educate your courts that electronic recording is allowed and convince them why it shouldn't be denied to your clients. If courts have installed electronic recording equipment to deal with criminal infractions and misdemeanors, they may not know that they can turn it on in those other types of cases. And I did see in the chat a question about whether electronic recording would be more useful to get tone, volume, cadence, transcript, etc. It could be, and you can check the government code section. In some cases, you can submit the electronic recording rather than a transcription of it for appeals. I imagine the Judicial Commission on Judicial Performance would also accept that.
All right. So as a result of what Jennifer just explained, coupled with the fact that the court reporters are statutorily mandated in certain types of cases, including felonies, juvenile dependency, some others. And so any court reporters that they have go there, and they have to go there. As a result of all of that, most unlimited civil, family, or probate courtrooms do not have a court reporter assigned. And just to be clear about what we mean, unlimited civil is essentially every civil case you can imagine, except for limited cases like small claims and unlawful detainers, as Jennifer said. So basically everything else falls into this unlimited civil category and is not being reported. Most courts do require that you make a request for a court reporter in advance. If you don't, then the court may say you've waived your right to request a court reporter. And as many of us know, even when you do make a request in advance, you will often arrive at the hearing and be told that the court is unable to supply one. They just don't have enough. So when that situation occurs, which is very common, litigants like our clients have very few options, and they are all bad options. The first is they can hire their own court reporter, okay? And that is typically $3,000 or more per day to hire a private court reporter. And typically, by the way, they charge not by the hour, but by like the half day. So even if it's like 20-minute hearing, you might be paying, $1,500 for that. You can ask for a continuance in hopes that a court reporter will be available on a future date, but there's no guarantee that that will happen. And sort of logic tells us that as this crisis goes on and worsens, there's actually going to be fewer court reporters in the future, not more. I will say anecdotally that for most part, we are seeing that judges will grant a continuance. They're not really resistant to that. It's just there's no guarantee that there'll be a court reporter at the next hearing. Or obviously, their third option is they can proceed without any record. So those are the options that our clients are faced with in court. Now, some litigants do have another option, which is to request electronic recording.
So Government Code 69957 prohibits electronic recording except in limited civil cases. Since the prohibition means no record in many cases, some courts have recently determined it is unconstitutional under some circumstances. Some of those courts have general orders or local rules that govern requests to use electronic recording instead when a certified shorthand reporter is not available. And that can be in all the other kinds of civil cases: family law, housing discrimination, landlord harassment, debt collection, under Civil Rights Act, all the rest. You should check your court's website to see if there is a general order or local rule. And we are going to take a look at LA's general order next.
So like Jennifer said, let's take a closer look at the general orders to understand some of the circumstances under which electronic recording is allowed in unlimited civil, family, and probate cases. While the general orders are pretty similar, there are differences, so make sure you do your due diligence and read the general order that's applicable in your jurisdiction. But to give you an idea of what's required, I'll summarize the 6 findings that judges must make in LA Superior Court to turn on ER in those cases. The judge must find that the proceeding concerns a fundamental right or liberty interest, that a party wants to have a verbatim record, that no court-employed court reporter is reasonably available, that the requesting party has been unable to get a private court reporter because the party can't afford one or one was not available to hire. The proceeding involves significant legal and or factual issues such that a verbatim record is likely necessary, and the proceeding should not, in the interest of justice, be further delayed. There are 2 final notes on electronic recording that I'd like to cover here. One, even if there isn't a general order or local rule allowing electronic recording in unlimited civil, family, or probate cases, lawyers can still draw upon the reasoning in them to advocate for electronic recording. And 2, even with electronic recording being more available, we're still seeing that proceedings are going unrecorded.
Yes, and just to pick up something that Erica said, if you're wondering, well, why wouldn't a court reporter be available for hire? There are many places that are remote, and they actually, it is very difficult to hire a court reporter actually in some of those places. So why aren't proceedings being reported if low-income litigants are entitled to it? And I think there's a lot of reasons for this. These are not all of the reasons. These are some of the reasons that we've come across. So as is probably pretty clear, pro per litigants frequently do not know that they have a right to a court reporter or how to ask for one. Often I think they just assume there is one there and that it's happening. They don't even know that it's not happening. Most judges do not affirmatively ask them. We're laughing because we wish that they would do this, but they won't. They don't ask litigants, would you like a record? Do you know what a record is for? It's for the purposes of appeal, or, having a word for word record of what takes place. You have a right to a court reporter because you're a fee waiver litigant, or even just, by the way, no record is being created. We are not seeing judges say those things for the most part. And then when people are represented, there are a lot of reasons why lawyers may not ask for a court reporter or any type of verbatim record for their client. They may not be aware that their clients are entitled to a free verbatim record to be created. They may not know the process for requesting one. Maybe they do, but they think it's futile because they know for a fact there's not going to be a court reporter at the hearing no matter what they do. Or, they simply forgot. They're aware, but, there's a lot going on. They are used to court reporters not being available, and now they're trying to develop that new sort of muscle memory of requesting it, and that can be difficult to do.
So what are the ethical considerations for lawyers related to preserving a verbatim record? Well, under Jamieson and the California Rules of Court, courts are required to provide indigent litigants with a free verbatim record made by a court-provided court reporter upon their request. Some courts have expanded the ability to get a verbatim record by allowing electronic recording when a court reporter is not available. In light of this, and given the importance of a verbatim record, what are the ethical considerations involved in securing a verbatim record for indigent clients? Under the California Rules of Professional Responsibility, lawyers have a duty of competence, a duty of communication with the client, and a duty of diligence, all of which are implicated here. There are also rules around when a lawyer has the authority to make a strategic call and when a client must be consulted. While this area of ethics is still evolving, we think all of these duties are implicated when it comes to securing a record for your client.
The first rule we're going to cover today is Rule 1.1, which covers the duty of competence. It prohibits lawyers from intentionally, recklessly, with gross negligence, or repeatedly providing incompetent legal services. Incompetence requires applying the skill and mental and physical ability that's reasonably necessary. And a lawyer can become competent by consulting with other attorneys, by studying or referring the matter out to another attorney. So how does the rule of competence apply here? Competency requires understanding the importance of a verbatim record, which we just talked about, and knowing how to secure one. It also requires lawyers to keep abreast of any changes in the law on low-income litigants' rights with respect to verbatim records and the court's duty to provide them. This includes knowing about those general orders and local rules we just talked about, as well as new published decisions and new court rules.
And the second rule that we're going to talk about is Rule 1.2, which is the scope of representation and allocation of authority. I think we all generally understand that lawyers have this inherent authority to make sort of day-to-day tactical procedural decisions in the case, and something that might be like a strategic decision, but that line can be kind of difficult to understand. So we have some helpful case law that's provided some guidance on that. And what's relevant to today's discussion is that courts have recognized that the decisions that impact appellate rights, the ability to seek judicial review, and clients' claims are all decisions that impair their substantive rights. Decisions that impair a client's substantive rights are decisions that need to be made in consultation with the client. So we're going to touch on a few of those cases here. The first one is a California Supreme Court case, Blanton versus Woman Care. And I'm going to read some of this because I think this language is very pertinent to this situation. And we feel strongly that this is an ethical obligation that we all have. So they said, considerations of procedural efficiency require there be but one captain per ship. An attorney must be able to make such tactical decisions as whether to call a particular witness, and the court and opposing counsel must be able to rely upon the decisions they make. In such tactical matters, the attorney's authority is implied in law. An attorney is not authorized, however, merely by virtue of the retention in litigation to impair the client's substantial rights or the cause of action itself. An attorney is without authority to waive findings so that no appeal can be made. Such decisions differ from the routine and tactical decisions, which have been called procedural, both in the degree to which they affect the client's interest and the degree to which they involve matters of judgment that extend beyond technical competence, so that any client would be expected to share in the making of them. And consistent with this, the Court of Appeal has recognized that waiver of right to appeal is a matter calling for the personal decision of the client and not consigned to counsel.
The next rule we think applies to this situation is Rule 1.4, the duty of communication. Under Rule 1.4, lawyers must promptly inform clients of any decisions or circumstances requiring client consent or disclosure, and keep the client reasonably updated on significant developments regarding their case. Lawyers must also discuss the methods used to achieve the client's objectives. And additionally, lawyers must explain legal matters in enough detail to allow the client to make informed decisions.
All right, so how do these duties of client communication and consent apply here? So we believe that the best course of action, the most compliant with these rules, is to consult with your client about securing a record and obtain their consent about how to proceed. So here's our recommendation of what this might look like. First, you would explain what a verbatim record is and what the consequences are of not having one. So something to the effect of, a verbatim record is a word-for-word account of what has taken place in court or during that proceeding. And if you don't have one, here are some of the consequences of that. You may not be able to appeal, etc. You would then explain your client's right to a free court reporter. So you would say, you have a fee waiver and therefore you are entitled to a free court reporter. The court is obligated to provide you with one. Then you would explain why a court reporter might not be available, even though you're entitled to one and you've made a request. And then you need to explain, consistent with what Jennifer was just saying, your client's options if a court reporter is unavailable and the possible consequences that would attach to each of those, right? So for example, if they choose not to proceed with a hearing because a court reporter is unavailable, they need to know that they could be facing lengthy, if not indefinite delays. And by the way, we've had cases that literally have been continued for a year because of no court reporter. They might have to make multiple appearances because you often do not know until the day of the hearing when you're there that a court reporter won't be there. So they will be having to come back to court every single time, possibly for no reason, incurring costs, missing work, childcare, etc. And you want to make a game plan for what to do in that event. On the other hand, your client might really urgently need the relief that you are in court to get. And they might ultimately decide to proceed without a record because they need that immediately. And that might be totally appropriate and a sufficient basis to waive their right to a verbatim record. And that is their decision, as we have just said. But if your client does want to do that, we think the best practice to cover yourselves would be to obtain your client's written authorization to waive their right, documenting that you've informed them of all these things and the repercussions, and this is the decision that they have made. If they want to continue to pursue a verbatim record, then it is your responsibility to take all the steps that you can take that are within your control to ensure that that happens.
There are other ethical rules that are also implicated here, including Rule 1.3 on the duty of diligence and Rule 5.1 on the responsibilities of managerial and supervisory lawyers. Rule 1.3 on the duty of diligence is more or less self-explanatory. Acting with diligence here includes advising the client so that they can make a fully informed decision, like Brenda just talked about, and taking action to preserve a verbatim record unless instructed otherwise by your client. And Rule 5.1 is worth underscoring. Here, supervisory lawyers must make reasonable efforts to ensure their subordinate lawyers follow the ethics rules in the State Bar Act. In light of this, it's critical for managers and supervisors to be aware of their ethical duties and overseeing staff, including with respect to the topics that we're covering here today. And we recommend training staff on these topics because of that.
Yeah, and one of the things that we're doing at Bay Legal is we're trying to like systematize this. We're working with supervisors to figure out how can we just make this a regular part of an attorney's, course of business, right? Maybe it's that they just file a request with the very first thing that they ever file in the case, for example. But the supervisors do need to realize that they are on the hook for these potential ethical violations.
In a recent published opinion, the First District Court of Appeal faulted trial counsel for failing to request a free court reporter when her client was entitled to one. Although this was a civil case with a right to counsel, the ineffective assistance of counsel holding is still something to think about when you're doing your own ethical analysis of this issue in your case or cases.
Okay, so we've covered the importance of communicating with your client about their right to a record. Your client wants to preserve this right. How actually do you do this? Okay, so first of all, you need to make sure that there is a fee waiver application on file. That's Judicial Council Form FW001. Most of you, if not all, are probably familiar with that. There are situations where even though your client is fee waiver eligible, you might not already have one on file. For example, if they filed a domestic violence restraining order, there is no fee for that. So there would not yet be a fee waiver on file. So you would need to file that if there's not already one. You would then also file Judicial Council Form FW020, which I believe we provided a copy of in the materials. That is the Judicial Council's sort of implementation of the Jamison decision effectively. So that is a form that is a way to request a court reporter. My opinion is that the best practice would be to make a simultaneous in the alternative request for electronic recording if the court reporter is unavailable, because given the timing of things, you might not know that the court reporter is not available until you get to the hearing, and then you want to make a request for electronic recording, but now there's no record to do that, and you haven't put that request in advance. So I would just do them both at the same time. You should also be looking to, of course, your local rules. I'm sure you know that, but also the local forms. So several counties do have their own local form for requesting a court reporter and for requesting electronic recording. They technically cannot require you to file those forms instead of the judicial council form, even though many of them will say that. Technically, they can't do that, but I don't think it really matters. I think that the key is getting something on file that says that you want to preserve your client's right to a verbatim record. So if they want you to use that form, I think that's fine. In fact, some of them are better than the judicial council form, which has a lot of flaws in my opinion. So that might even be better. I highly recommend that in addition to this, you file a brief in support of your request, like appoints and authorities. And I have provided samples to you guys in the materials. One is, and these are templates you can use, copy, paste. Please use them. We want you to use them. One is a sample for a limited case, like an unlawful detainer case. Another is an example of an unlimited case, which in this case is a family law case. Both of them are for Contra Costa County, which has a general order. So they are based on the general order that Contra Costa has. The reason why I think this is so important is because when you get to a hearing and you've made the request and there's no court reporter there and they're denying you, the record, there's no record of what you're saying. You can make all the arguments that are that would be in a brief, but what's the point of that? Because there's no record of the arguments you're making. If you file this brief in advance, at least that will be on record. And if you need to writ or appeal this, you can say, we made these arguments, we filed this brief. I also would absolutely suggest that you email the department clerk in advance of the hearing. In fact, I do it repeatedly, to be honest. And you want to make sure, hey, we filed this request. We have a hearing on Thursday at 9 a.m. Can you confirm that there's going to be a court reporter there, please? Or can you confirm that the court will be electronically recording the proceedings? At the hearing, I highly suggest you again reiterate this and confirm, because we've had situations where there's a court reporter in the courtroom sitting there and they did not report the proceedings and the attorney did not know that. We've also had situations where the courts have said to us, hey, we're electronically recording all of our unlawful detainer cases. And then we find out actually they're not. So what you should do at the beginning of your hearing when you're making your appearance or whatever, you can just say, Your Honor, before we begin, can we please just verify that the court reporter is reporting this? Or can you please verify that the electronic recording equipment has been enabled?
Those are some great points there, Brenda. Thank you. So now let's explore a little more how your ethical duties may apply through some hypotheticals. So Hypo 1. Your client is eligible for a free court-provided court reporter, and you've requested a court reporter for an upcoming case management conference, but none are available on the date of the hearing. The court offers to continue the case management conference to another day when a court reporter might be available. You decide to proceed without one because of the routine nature of the conference and because your client needs urgent relief and cannot delay the trial date. You do not consult with your client before making the decision. So, does the decision to proceed without a verbatim recording implicate any of the ethical rules? If you could drop into the chat whether you think rules are implicated, and maybe even if you could say which ones, we'd love to hear from you and see what your thinking is on this. So I'm going to give you a good minute to think about this and let us know what you think. Venuta says communication and competency. Ugochi says yes, duty to communicate to client. Great answers. I love these. See if anyone else wants to chime in. Rosa Maria says yes, duty of competence, duty of communication. Great. Okay, so I think, yeah, you guys picked up on a lot of what we're laying down here today. Appreciate that. So now let's think about this. What if you did advise your client of the risks and benefits to proceeding without a verbatim recording and they agreed to proceed? Does that change your perspective on the scenario? And would anyone even like to come off mute maybe and share your thoughts on this? Or drop in the chat? I know I personally would feel better if I had at least chatted it over with my client first, said, I think this is what you might be faced with. Here's what we might want to do. Yeah, Gucci says maybe, but I would want it in writing. Yeah, good point. Okay, well, let's proceed to our recommendation. Oh, Miranda, great. I love this. As long as the client makes an informed decision. Yeah. And memories fade. That's a good point, especially if it's, a month later and you lost and your client's like, why can't I appeal? Well, remember we talked about getting a record. I don't remember that. Yeah, absolutely. So our recommendation in a situation like this is because you never know what might come up, even in seemingly routine hearings, the best practice is to always advise the client about how proceeding without a verbatim record could impact their case because of the impact it can have on substantive rights. If an appealable issue does come up during an unrecorded proceeding, we think rules 1.2 and 1.4 on communication and scope of authority indicate that the attorney should be consulting with their client about securing a verbatim record. And because a court reporter is frequently not available, we recommend talking to the client in advance of the hearing about their options. I think this would include, talking to your client about how likely it is this judge will do something unexpected in your experience. As lawyers, right, we can give legal advice, not just legal information. You could talk about, in my experience, this judge is like just a straight shooter. It's very unlikely they will go off script or consider, opposing parties' motion in limine or opposing parties' expert witness request at this case management conference. They're going to stick strictly to what was on the agenda that was sent out. Or this judge is a little bit all over the place. I have no idea what they'll think they want to talk about today. I really do think we need a record just in case something weird happens. Talk that over with your client as you're discussing the options. And then, if you have some idea about how long a continuance would take, give them, in the last few months, they've been having them every 3-4 weeks, or actually continuances are going out 3-4 months. Because that may be important information for your client when making this decision. The more prepared ahead of time you can be for how to handle it if you show up and no court reporter's there, I think the better.
All right, so let's move on to Hypo 2. Hypo 2 says you request a free court-provided court reporter for your client's hearing and a request for a domestic violence restraining order. You know this will be a fact-intense, complicated hearing with several witnesses and evidentiary submissions. A court reporter is present at the start of the hearing, but halfway through the hearing, they leave to cover another courtroom. And so the question we have for you is, what next steps should you take considering your ethical obligations? I'll give folks a minute or so to think about this, and feel free to share any thoughts you have in the chat or even come off mute if you'd like to. Jocelyn says, request a continuance to have a reporter present. That's definitely one of the options. And Carrie says, ask for a short recess to discuss with client. Also a great thought. I'll give it another couple seconds in case anyone has anything else to share. Here's our recommendation. So under the hypo, the court reporter has left partway through the hearing, and so there's no longer a record being made, our first step would be to request electronic recording if there is an applicable general order or local rule allowing it, or a colorable argument we could make. And if that request is denied, then we'd ask the judge to put their reasoning and findings on the record. And this fulfills the Rule 1.3, the duty of diligence. I wanted to give a quick practice note about requesting electronic recording, which will sort of reinforce something that Brenda said earlier. If the client wants a verbatim record, you should request a court reporter and electronic recording simultaneously before the hearing and make arguments in your request as to why the proceeding meets the standards laid out in the general order or local rule. We recommend this because if you try to make a request for electronic recording for the first time on the day of your hearing, once you know a court reporter isn't there or has to leave early in the case of this hypo, the judge may decide to continue the hearing so they can further consider your request. We've heard of this happening to other legal advocates, and it's a scenario you want to avoid if you can so that your client can have their day in court as soon as possible. Also, be prepared to make arguments at the hearing for the use of electronic recording, and the sample motions that Brenda referred to that are included in the training materials will hopefully be helpful with that. So back to the
sorry, Erica. Go ahead.
Huh?
I was going to say there was a question in the chat, so when you're finished, I'll read that.
Okay. So returning back to the hypo, if your request for electronic recording is denied or requesting electronic recording isn't an option, you'll hopefully know already what to do because you'll have discussed this possibility in advance with your client in accordance with Rules 1.2 and 1.4. But if you haven't been able to talk to your client in advance, make sure, like one of the participants noted, to consult with your client about their options, which include continuing the hearing or proceeding with the hearing, even though it will be unrecorded. You could also discuss seeking a writ from the Court of Appeal challenging the denial of electronic recording as well. And you'll want to make sure through this conversation that your client understands the risks and benefits of each approach. This particular hypo involves a DVRO hearing. So this would include explaining how the lack of verbatim record could negatively impact their ability to appeal a wrongful denial of the restraining order. And even if your client wins the restraining order, the lack of verbatim record could still be detrimental to their interest in future court proceedings, including if the client requests a renewal of the restraining order several years later. And then finally, if the client decides to proceed without a verbatim record, as we've noted earlier, the best practice is to obtain your client's written authorization to waive their right to a verbatim record, documenting that you've fully informed the client of their rights and the repercussions of their decision.
Thanks, Erica. So one thought that just occurred to me quickly is to make sure that folks know that the statute that Jennifer referenced earlier that permits electronic recording in limited cases, it is permissive. It doesn't require in its own language that the court do that. So you might run into that situation, which is why we recommend that you make all of these other constitutional arguments about people's rights to a verbatim record, even for electronic recording in a case where it's permitted. Thomas asked a question. San Francisco requires their local form be filed 5 days before the proceeding. Is that legal? This is a great question. My opinion is that that is not appropriate. The Jameson case is a little, the language is a little confusing. So at times they use the word upon request, other times they don't. But in the Jameson case, the plaintiff who was in pro per had not actually requested a court reporter or anything in advance of the hearing or the trial. And the Supreme Court admonished the trial court for not asking him in the moment, hey, you have a fee waiver. Do you want a court reporter? So to me, that indicates that he could have made that request in the moment and that would have been sufficient. I don't think procedure can get in the way of people's constitutional rights, and especially when we're talking about pro pers and low income litigants, et cetera. So we would argue no, but I will just caveat that with there is nothing necessarily precisely on point.
Yeah, and I would just to piggyback on that, say there is a rule of court 2.956C, which says requests should be made 10 days in advance, but rules, local or statewide, can't conflict with someone's constitutional rights. And in many cases, of course, you don't know that far in advance that a court reporter is required. But I would also, like Brenda, argue that you can't take away someone's constitutional rights based on a rule that has no purpose bearing on that constitutional right. So making a request in the moment should be sufficient. And so if you run into cases like that, especially ones where you didn't have 5 days advance notice, whether it's because you're coming into the case or whatever, you can always reach out to Family Violence Appellate Project for some technical assistance on, filing a writ or doing some sort of post-trial motion to remedy that. Obviously, don't make it hard on yourself. If you can make the request 5 days in advance, go right ahead.
Yeah, but that reminds me that a lot of folks who are doing, for example, unlawful detainers, I mean, they don't even know the day and time and department that they're having a trial until the trial call, for example. Or there may not even be 5 days before the hearing, let alone 10 under the Judicial Council rules. So, like Jennifer said, do your best. If you're unable to request one in advance and the court has a problem with that, maybe a continuance is appropriate, and then they can get your request granted at the next hearing. All right, so our last typo, at your client's hearing, after you've been told that the court is unable to satisfy your request for a court reporter, you present argument to the judge on why they should allow electronic recording to create a verbatim record consistent with the jurisdiction's general order. The judge summarily denies your request. They do not explain any of their reasoning for the denial, and there is no verbatim recording of this decision. How should you respond in light of your ethical obligations? And again, just go ahead and pop it into the chat or come off mute, share your thoughts. This is essentially the case scenario. You've made all your requests, all of them have been denied. What do you do? Ask for continuance. Probably denied also. Says an eviction defense attorney. Understand, yeah. File a writ. Okay, great ideas. If you want to come off mute, go ahead and raise your hand and the host will unmute you. Ask the judge to put the denial and reasoning in their order. Stars for Renee. Judge, I ask that the minute order reflect that you denied my request to follow the rules without any explanation. I like that one, especially. A little sass in there. These are fantastic responses. If anyone has additional, please go ahead and put them into the chat. So yes, obviously you want to consult with your client. Presumably you've already done that in advance because we've been telling you throughout this training to do that. You are advising them or have already of their options. And we know already that those include, as has been mentioned, continue the hearing until a court reporter or electronic recording can be provided. You want to explain to your client any effects that this delay might have on them, on the case. In the case of Tom's example saying, well, you can request a continuance, but it might be denied because if this is a landlord-tenant case, right, presumably the landlord is being prejudiced by the denial, right? You would still want to insist on that. That's not your client's fault. You didn't cause this problem. The court is not upholding their obligations. You can, of course, proceed without a verbatim record. Again, you remind your client if something bad happens. You could try to appeal the denial of the electronic recording to seek a new hearing with a verbatim record. There's no guarantee, of course, that that would be successful. You can try to ask for a non-verbatim record. I think somebody was suggesting put that in an order. You can ask for a settled statement. explain the risks of the inaccuracies of those, and sometimes those are also not enough for an appeal either. And you want to preserve your client's ability to challenge the denial of the electronic recording pursuant to Rule 1.3, and I'm going to talk about specifically how you can do that. But just as a side note, the Court of Appeal has ordered a new hearing when requests for a court reporter were improperly denied, resulting in no verbatim record of that hearing. So creating a record of the court's denial of the electronic recording gives you a similar basis to argue for a rehearing if the court ends up making erroneous rulings that you would need to appeal, but you can't because there's no record. We don't know how a court of appeal would respond because the use of electronic recording under the general orders is relatively new. So I'm going to put this one on the screen so that you guys can follow along. So this is our proposed approach if all else fails, every request has been denied. First thing I would do is I would ask the court to enable the electronic equipment, similar to what somebody suggested, in order to put the request, the denial, and the reasons on the record. If that's denied, I would ask that the request, denial, and reasons be put explicitly, like very detailed into the minute order, and I kind of prefer this instead, submit an order to the court and have them sign it right then and there. So I would bring a proposed order with some blank spaces to fill out like the reasoning that as far as you understand it, or you can ask the court, can Your Honor please fill out the reasonings for the denial, and then ask them to sign it right there. If your client still wants a record, you can request a stay of the proceedings to allow for the opportunity to file a writ, as someone mentioned, that challenges the denial of the record. Ideally, you would have stay paperwork with a proposed order ready to go. That gets signed, the proceedings are stayed, and you file the writ petition. If you ask for a stay and they deny that request, you can ask your client whether they want to proceed with a hearing, or you've already had this discussion, or seek a continuance, as Tom mentioned. If they do choose to proceed, rather than all these other alternative options, ideally someone can take like close to verbatim notes. So you might have like a colleague sitting in the gallery just typing away furiously, trying to take as much verbatim notes as they can. We have used that as a basis for a writ. It wasn't a successful writ, so take that for what it's worth. I don't think that was part of the reason. If you get a continuance, you could consider filing your writ during the continuance before the next hearing in order to compel the court to provide a court reporter or electronically record the proceedings. So this is where you've asked for the stay was denied, you've asked for continuance, the continuance is granted, it's a short continuance. You can still file the writ during that period, and you can ask the appellate court to grant a stay since that was denied by the trial court. And it's a lot of information, I know, and you don't have to memorize this, and it's on the slides, and you can always reach out to us at any time for any thoughts or advice on this.
So thank you everyone for your time today. We hope that you leave this training with an understanding that in accordance with your ethical obligations, you should be communicating early with your client about securing a record, making sure they understand their rights, the importance of a record, and how to try to preserve a record, and then get direction from your client on their desired course of action, given their goals and the need to exercise diligence in taking this action. And we have 1 minute for questions.
And I am available to actually stay on a little later if anyone does want to stay and ask further questions. And I'll let Jennifer take this.
What am I taking?
Requesting technical assistance from FF.
Oh, sorry. Next slide. Yes, I apologize. I'm still looking at the chat. So we have all our contact information there, but also want to reiterate Family Violence Appellate Project is your State Bar funded support center. We are here for all your needs. If you need to preserve issues for appeal, if you want technical assistance on getting a record, if you want to talk through filing a writ, we have a dedicated writs attorney. We can maybe even do the writ with you or for you. So please reach out to us anytime you have questions or need assistance. It is literally our job. Thank you.
And it may not be precisely my job, but it is my passion. So reach out to me anytime with any questions about this. Thank you all so much. We will end the recording. And if anyone does want to hang around and ask a question, I can stay. Jennifer and Erica are going to take off. Thanks, everyone.